Good morning, everybody, and welcome to this webinar, which is organized by the European Lawyers Foundation and the Council of Bars and Law Societies of Europe on anti-money laundering for lawyers, the new AML package and general practice advice, practical advice. We have a lot of people joining us this morning for this webinar, and so while you're all entering, I'm going to make a number of important announcements. My name is Jonathan Goldsmith. That's not one of the important announcements. I'm Senior Project Counsel at the European Lawyers Foundation, and I will be your moderator. Now, we very much encourage questions to our speakers today, but please put them in the question and answer box at the bottom of your screen, Q&A box. Please do not put them in the chat box. Your question will almost certainly not be answered. If it's in the chat box, put it in the Q&A box. We will try to answer all questions. There are a lot of people at the end of each session, so that's how it will work. We're very happy if you use the chat box to say hello to us and to introduce yourselves, but put the questions in Q&A. This webinar is being recorded. The recording will be available on the European Lawyers Foundation's website, and it'll also be uploaded on the Foundation's YouTube channel, which is at EU Lawyers Foundation, and you're invited to subscribe for free access there to past and future webinars. This webinar will be in English and no interpretation is provided. Now, two very important points here. We get a lot of questions about these 2 points. The first thing is the slide packs, which you will see. I have seen them in advance. They are excellent and packed with information. They will be put on the European Lawyers Foundation website. We often get a lot of questions saying, will we be able to see the slides? Yes, they're excellent slides full of information. Even if our speakers can't go through them all today because of time, you'll see them on the Foundation website. Number 2, the Foundation does not produce continuing legal education certificates itself. What you have to do if you want a certificate for participating in today's webinar is apply to your bar, and your bar will ask us for confirmation that you have participated. We will send the information of how long you were connected for to this webinar to your bar, who will issue you with a certificate. So please don't ask us for the certificate. And finally, our next webinar will be on the 18th of March from 9:30 to 12:30 on intellectual property and its enforcement in the EU. More information will be coming on social media. That is the end of the questions, of the information, should I say. We encourage questions. Now we will begin with the webinar itself. It's my great pleasure to introduce the president of the CCBE, Pierre-Dominique Schoup, who will make some introductory remarks. Pierre-Dominique was president of the Swiss Bar Association from 2013 to 2015 before becoming president of the CCBE at the start of this year. Pierre-Dominique, over to you.
Thank you, Jonathan. Dear colleagues, hello everybody. On behalf of the CCB, I would like to welcome all the participants to this webinar organized by the European Lawyers Foundation and the CCB. We as CCB are delighted and are always delighted to be associated to this very important event. I would like to emphasize the fact that we received more than 2,000 registration, but could only accept for practical reason 1,000 participants. This shows the great interest of European lawyers in this so important topic that is anti-money laundering legislation. You have seen that last week in Frankfurt has been chosen as the seat of the new EU organization in this matter. This shows how actual we are with this topic. Indeed, the organization of this webinar is timely also, as the new AML package will soon be finalized and adopted, introducing several important changes for lawyers of which we're going to talk about today. I would also very much like to thank the Commission representatives for their availability to explain the upcoming changes to the AML framework, and our ex-CCB experts who agreed to speak today. For the CCBE, AML has always been considered as a priority, if not a strategic topic, and has participated in various activities, raising awareness among legal professionals about their anti-money laundering related duty. I would also like to take the opportunity to thank Alonso Hernandez and Jonathan Goldsmith, which we have just heard, for their always so competent commitment and involvement in the organization of this event and also of all the other events of the European Lawyers Foundation. I therefore hope that this webinar, covering also general practical advice, will be of assistance to you, and I wish you very, very interesting discussions this morning. Thank you.
Thank you very much indeed, Pierre-Dominique. And now we move into the first session of this webinar, which is on the EU's new AML package. We will have 45 minutes for this, and there will be two speakers because there will be two parts. First, the European Commission, and then somebody on behalf of the CCBE will stress those parts which are particularly relevant for lawyers. So starting with the presentation from the European Commission, which is a general presentation of the upcoming changes, we're very pleased to welcome Constance Deshonnette, who's Policy Officer at the European Commission in the DG for Financial Stability, Financial Services, and the Capital Markets Union. Constance, over to you. I see her slides are there.
Yes,
That's
okay.
great. On you go,
And
Constance.
you can hear me as well.
Yes, we can hear you.
Okay, that's marvelous. Okay, so I like to say that I'm very delighted to see so many people are attending this event, as Pierre-Dominique just say. That's really your interest that you have in the topic of combating money laundering and terrorist financing, and therefore the brand new AML package, which has almost been adopted. So I will come back on that later. So Claudio Cucuzza and I split up the presentation of this package, as Jonathan explained. So for my part, I'm going to give you a general presentation of the whole package, meaning that I will present to you all the four texts and all aspects, not just the elements that concern the non-financial sector and the legal profession. So Claudio will give you a more specific presentation, but that's also the reason why I start. But I will stand until the end of our common presentation, and I hope I will be able to answer all your questions. So firstly, let me give you another look of the timeline. So in July 2021, the Commission issued a package of legislative proposal to overhaul the current AML-CFT framework in the EU. The negotiating process has been ongoing with co-legislator, and in the very last weeks, we reached an agreement on the text, and the last week we have decided to sit, as Pierre-Dominique also said, for the new authority. So of course, there are differences between the Commission original proposal and the final text. But since we have an agreement in our hands, I will focus during my presentation on some of the key elements of the final outcomes. So firstly, what is the package? The package is made of four legislative proposals. The first element is the new AML regulation. This is a very ambitious leap, as we are setting directly applicable rules toward obliged entities. That means that the private sector, so you will implement the same rules no matter where in the European Union you are. Secondly, we have the AML directive, the sixth AML directive. This covers the rules which are intended for public authorities. The idea here is to leave some room, because it's a directive and there is a margin of transposition, for member states to decide how they wish to structure the AML system, including the functioning of the national supervision, but also the organization of the financial intelligence unit, the FIUs. A bit apart, there is the recast of the transfer of fund regulation. Here we're extending this regulation to crypto assets. And fourth and finally, that attract a lot of attention as well, is the new AML authority. It's a regulation, and this authority will be called AMLA. And yes, the seat will be in Frankfurt. So now let's start with what we call the rule book, which is made of three texts. So the recast of transfer fund regulation, and the AMLD and the AMLR. Very briefly on TFR, this recast extends the scope of TFR to transfer of crypto assets. So full information of originator and on the beneficiary have to be included by the crypto asset service provider with all transfer of crypto payment. Just like just like PSP is currently doing with wire transfer. Here we have just aligned the European legislation with the fat of work on what we call the travel rule. This text will be applicable as of the 30 December 2024. Now on the two other legs of the rule book, which is the AMLD and the AML regulation, the key distribution of the rule content in both texts have been made according to the addressees of the rule. On the one hand, the rule for the private sector, so the obliged entity, will be in a directly applicable regulation. On the other hand, the rule for the public authority are in the directive. And you can see on this slide the topics that both texts cover. Let's work on the new AML regulation now and the new obliged entities. So among the main novelty, there will be new obliged entity, for instance, football clubs and agents, traders in high-value goods such as jewelers, horologists, and traders in high-value motor vehicles, boats, and planes. But member states will have the flexibility to add or exempt, subject to risk assessment, some of obliged entity. As regards customer due diligence, I will not be able to go through all the new novelties, but if I have to choose some, so firstly, the new occasional transaction threshold that have been inserted, as you can see in the slide, including for cash transaction above 3,000 euros. The rule related to simplify and enhance due diligence have been specified and therefore harmonized. Co-legislator also inserted rule for preventing de-risking by adding the obligation to record steps taken when onboarding or rejecting a client. And most of all the rule will be complemented, further explained by technical standards in the coming years. Let's now zoom on beneficiary ownership. So IMLD5 lacked granularity, which led to different setting methods of identifying BO or inconsistent way of calculating the threshold. So now we have put much more detailed rules, and those all concern firstly that this would clarify the type of information needed to be identified, and also give very detailed calculation rule for corporate entities and other categories. The general threshold for the ownership is kept at 25%. However, the Commission is empowered to identify categories or activities of entity that pose higher risk and for which a lower threshold will be justified. However, the threshold is framed. It cannot be higher than 15% unless the Commission consider it's proportionate to go higher. But in any case, it should be risk-based. Another interest element is a requirement to register beneficiary ownership information for foreign legal entity in specific circumstances where, for instance, there is an interaction with the internal market, that is, for instance, the purchase of real estate or the acquisition of a high-value goods. Another big novelty of the package is the inclusion of the justified and proportionate limitation on the use of large amounts of cash. This limitation is 10,000 euros. Have been also inserted the obligation of reporting to the FIU only for credit institution and financial institution of deposits of 10,000 euros. To conclude on IMLR, the idea here is really that anywhere in the single market, the same activities that carry the same risk will follow the same rules. Now let's move to the other legs of the rule book, which is the AML directive, the 6 AML directives. So sorry to repeat myself, but these rules are for public authorities. So as regards the supervision, the main novelty are the following. So very importantly, the directive provides a common framework for the power to impose pecuniary sanction and administrative measures. The disparity between member states was one of the more major weaknesses in our current European framework. This framework will be further specified by a technical standard as well. Other points, IMLD will give a legal basis for IML supervisory colleges, and they will be both organized in the financial sector, which was already the case based on the EBA guidelines, but also, as that is a novelty, in the non-financial sector. But it will be a possibility for the non-financial sector, contrary to the financial sector where it is mandatory. Another point that should interest you is that the co-legislator have introduced into the directive a public oversight over the self-regulatory bodies, which as often as you know, for the legal profession, the Bar Association. To be very clear on this point, the aim is no way to replace SRBs, and therefore in no way for this authority to have access to lawyer files. It is simply for the public authority to check that the SRB are carrying out their supervisory activity properly, and that's all. As regards FIU now, I have to mention.
Constance, only one
yes.
second. There's a note saying that could you speak a little slower? So I think for people whose first language is not English, it might be better if you went a bit slower. Thank you. Sorry to interrupt you.
No issue. Point taken. So maybe let's go to FIUs. So as regards the FIUs, if I have to mention only one point, which is really a novelty, the AML directive will give the legal basis to organize joint analysis by FIUs. That means very concretely that it will be possible, for instance, for the Belgian and the German FIU to conduct a common analysis on the cross-border cases. It will not more as it is now limited to exchange of information, but FIU will be really able to work together on a common case. The AMLD also provide a framework for setting up registers. So as regards the beneficial ownership register, AMLD increase the power of the entity in charge for the register to better verify the accuracy of the information submitted, including by doing on-site check and by imposing sanction. As regards the bank account register, we have proposed to interconnect them so that the FIUs can access information held in bank account register of other member states. In the same vein, the co-legislator have proposed to set up a single digital access point for FIUs and competent authority to access information on real estates. This is not a register or database, but about making access to data easier and more efficient, particularly where it's held in those information is held in several databases or by several people. Let's now focus on the new AML authority, the AMLA. So AMLA will become the center of the new AML supervisory system and will have two hats. In the one hand, AMLA will be at the heart of the AML supervision. Therefore, it will have direct and indirect supervisory power on obliged entity of the financial sector and only coordination power for the non-financial sector. On the other hand, AMLA will be in charge for the coordination and support mechanism for European FIUs. This slide shows the scope and delimitation of the three types of the supervisory power of AMLA. For financial sector, AMLA will be tasked of direct supervision for only some of the riskiest from the AML risk point of view, financial obliged entity, and which operate those entities in at least 6 member states. Those entities will be 40 for the first selection batch, and it will be possible later to increase the number of the entity directly supervised in the financial sector by AMLA. For the other obliged entity in the financial sector, it's really the very big majority of the financial sector. AMLA, we only have indirect supervisory power. For the non-financial sector, as I said previously, it's only oversight power. Here you can see in this slide the power and tools that AMLA will have for the whole AML supervisory system, meaning for the financial and the non-financial system. AMLA, for instance, will be charged to draft a supervisory methodology, a handbook in a way. AMLA will also carry out thematic reviews as EBA, so the European Banking Authority, does currently in the financial sector. And AMLA will also in charge of an enriched, compared to the existing one, database. So on this slide, you can see the power as regards the financial sector. So for the selected obliged entity for direct supervision, AMLA power are the same than the current national authorities have. So AMLA can do on-site visit, off-site visit, impose sanction and administrative measure. As far as concerns the indirect supervision of the financial sector, AMLA will have several types of power, and I cannot focus on all this power, but for instance, AMLA will be able to assess the state of supervisory convergence. That means that AMLA will assess the supervisory practices of the supervisors. Now for the non-financial sector. So AMLA will have again, I repeat myself, not indirect supervision role, but just oversight role. AMLA will be able to conduct peer reviews over the non-financial supervisor and the public authority oversighting SRBs. And SRBs, so your bar association, could participate to those peer reviews, but only on a voluntary basis. There's no monetary, no obligation there. AMLA will also have the possibility to launch that we call an alleged breach of union law procedure. It's a warning procedure. Here, the co-legislator have introduced the sole possibility for AMLA to issue a non-binding warning, where AMLA issued where a recommendation of the authority towards a non-financial supervisor is issued and is not complied, AMLA will not be able to go further. There will no commission opinion on that. AMLA could just issue a warning to say what it thinks about this issue. In case of disagreement between supervisor, AMLA will be able to mediate between them, but contrary to the power that AMLA have in the financial sector, the opinion of AMLA will be not binding. Finally, AMLA will be tasked to coordinate and facilitate AML supervisory colleges in the non-financial sectors. As regards FIUs, AMLA will facilitate the cooperation among European FIU, in particular for the joint analysis, as I mentioned previously. And to conclude, I'm sorry I've been fast, but had many things to say. I would like to outline the timeline for the implementation of the package and the task of AMLA. So the package should probably be published in June this year or even in September, but we are fairly confident that it will be possible to do so in June. It depends on how long it takes for the translator to translate the whole package into the 24 EU languages. When the text of the package is published on the official journal, AMLA will enter into force 20 days later. However, AMLA will not be able to accomplish all its tasks from the outset. First and foremost, AMLA will have to draft several so-called level 2 and 3 measures, so the regulatory technical standard that specify the provision to fully finalize the package. From mid-2025, most of the article of the AMLA regulation will be applicable, and AMLA will then be able to carry out horizontal tasks such as thematic review, mutual assistance, as well colleges, and the management of the database. AML regulation, AML directive will begin to apply 3 years after the publication, so also in July 2027, and AMLA will begin direct supervision in the financial sector from January 2028. So I hope I haven't been too long, and above all that it had been understandable. I will now pass the floor to Claudio, and I will be happy to answer your question you may have after his presentation.
Thank you, Constance. Before you go, we have a couple of questions. First from Silke Gottschalk. I should have said in advance of your presentation that there may be some questions you can't answer because the AML package is not completely finalized. So we just be aware of that. But there are a few questions. So question one is, will European law firms be an obliged entity under the new AML regulation?
Yes, there is no changement from the IMLD5. There's the same carve-out. All the activity of litigation of the law firm will not cover by AML obligation, but the other activities, as it mentioned now in the Article 3.3 AML regulation, and exactly the same that we have in the current AMLD, lawyer will be obliged entity, but there is no changement, will it not?
Okay, from Paul Egan, SC, there's a question saying, are you disappointed that the new directive and regulation reinforce concealment from the public of beneficial ownership registers by limiting access to those with a tightly defined legitimate interest? Surely anyone having dealings with any company has a right to know the owners.
Yeah, so I'm not disappointed, or I don't have some feelings on that. We need to follow the European Court of Justice on that point, and we are work hard to define what is a legitimate interest. And I think with co-legislator, we are find the right balance. And now it will be able for the legitimate person to access the beneficial ownership, and in the same time, we are we have really make sure that the private life are just protecting. So I think we have found just the right balance.
Next question. Is there any sense today as to which types of institutions might make it to the list of 40 subject to direct AMLA supervision?
Again, can you, I'm not sure to understand the question.
In other words, which types of institutions will be subject
yes, okay.
directly to AMLA supervision? Sorry.
Okay, that's financial sector, not non-financial sector. It will be the 40 riskiest. How we measure this risk, it will be based on what we call the inherent risk, and for the first selection process as well, a bit of residual risk. Inherent risk is really what type of product, where is the entity operating, and you take all this objective risk and you make the inherent risk of the obliged entity. And what we call the residual risk is when you take the mitigating measure put in place by the obliged entity, then you can reduce or increase the risk of the obliged entity. So it will be criteria super precise, and that should be drafted by AMLA now, those methodology, and also other criteria, because we need to have an added value for this European supervision. It should be a cross-border entity, so at least in 6 member states. And so we don't know, not really, to be fair, we try to figure out which type of entity we can sync to some, but really we don't know, because we cover all the types of entities. They will be cast. So crypto asset service provider will be in the pool of entities that could be selected. And for each type of entity, there will be particular criteria. So you can have, for instance, I don't know, Santander, and at the same time, one of the big casts. We will have try really to have all the different type of obliged entity for the direct supervision.
Okay, there are 2 very quick questions before we move on. One is, are you expecting a lot of national gold plating to happen on the back of the discussions that took part when agreeing the AMLA package?
Right, that's European negotiation. Of course, each country have different its position, but for this package, for this text, I'm willing to admit that there were great same understanding of the risk and the discussion. There were discussion for instance cash, of course, because you know that the European country do not have the same relationship with cash, but really it was like a common understanding, and the negotiation was smooth between member states, for instance.
Okay, there are more questions, but we will move on because we
Yeah.
need to keep very tight time limit. And I hope to we won't delete the questions and to put them then to you and to Claudio at the end of his session.
Okay.
So we move on then to our next speaker, which is on the same topic of the new AML package, but this is to do with the key changes introduced for lawyers. And our speaker is Claudio Cocuzza, who is an Italian attorney and member of the Milan Bar. He's chair of the CCBE's Anti-Money Laundering Committee and a member of the Anti-Money Laundering Committee of the Italian National Bar. So, Claudio, over to you, and we look forward to hearing from you.
Thank you, Jonathan. I hope you can hear me, yes?
Yes, we can hear you.
And of course, thank you very much to Mr. Zaunet to accomplish the almost impossible mission to concisely present the entire package in 18 minutes. It was a record, and we appreciated very much the efficacy and the overlook. I hope to be able to do the same, but my challenge is different. My challenge is to respond to the question, what is going to happen for us lawyers when it comes to this news package of legislation? And here, the answer, and I will really focus on the specificity and the specific provisions which pertain and cover lawyers with very specific angles. Let me start with the AML regulation. Here, already Constance has outlined the changes in general that we will have to learn and study. But the one that we were more concerned with was, of course, the perimeter of the exemption for lawyers when it comes to the requirement to make STRs, to file suspicious transaction reports. This, of course, is an area which is very delicate, very complex, and it pertains and it covers really the core of the obligation for lawyers to report suspicious transactions, which you all understand is key for us to understand when it comes to our profession. The legal privilege, secrecy, is a milestone of it's in our DNA, and we came to terms with these important changes introduced by AML legislation when it, in 2006, when we were introduced in the list of subject entities. And we discovered, and we had to learn how to face with the challenge of making suspicious transaction reports, which is a very important part of our set of obligations. So let's answer the question, has there been changes when it comes to STRs? And to respond, I would say not substantial changes. The perimeter of the exemption has not changed. So we will benefit in accordance with the regulation with the same exemption, which, as you know, covers two areas: the ascertainment of the legal position of the client, and of course, the legal representation of the client in court. So I have put those aside. That has not changed. When it comes to those two items, we will be able to trigger the exemption, and therefore we will not be obliged to make the STRs. Of course, it remains the difficult challenge of qualifying the notion of ascertainment of the legal position of a client. But that has not changed. The wording of this specific set of exemption is not changed. This is, I think, important because during the dialogue with the Commission and during the trialogue and during the time in which we were engaged as CCBE in making ourselves heard and in clarifying our position when it comes to the changes, we were, of course, concerned of the change with respect to this exception. And I think that we did a good job when it comes to perimetering, continuing to perimeter this exemption the way it was phrased. Because in some proposal, the exemption itself was going to be changed. So this is not changed. So this is good news. Then let's move on. Has there been a specific nuance when it comes to STRs for lawyers with regards to the filing of the STR? Yes, there's been basically an exception to the exemption. So in the context of the changes, the policymakers in Brussels introduced the one that you see in the slide, i.e. the exemption shall not apply, and you can read it, when the obliged entities thereafter therein take part in money laundering, letter A, B, provide legal advice for the purposes of money laundering, or C, know that the client is seeking legal advice for the purposes of money laundering. Let me get to the point here right and now, telling you that this type of exemption, in my opinion, is not significant in the sense that it's clear, my friend, that when it comes to this type of situation, we are not anymore in us being unwittingly used in the context of in the context of our relationship with the client who comes, conceal himself in terms of what he really wants to do, and then tries to use us as a tool to money launder or to finance terrorism. In the exemption list A, B, C that I just read, the situations are radically different. A situation in which we are taking part in money laundering. Of course, if we do that, we are committing a crime. So dear colleagues, it's clear that this is, we cannot be exempted from any type of filing of STRs. We are indeed, if we consciously take part in money laundering, committing a crime, and a serious one. Then when we provide legal advice for purposes of money laundering, but also in this context, dear colleagues, it's clear from our ethic code and ethic rules, it's very clear, and we all know that we cannot provide legal assistance when we are aware that the client pursues illicit aims. So it's even broader. Our ethical obligation is even broader than that. So in this context, this exception to the exemption, this is how it's been shaped in the new regulation. I don't think it will really affect us. To the contrary. Now, also the last point, when we know that the client is seeking legal advice for the purposes of money laundering, again, in this context, we are always in the same perimeter. We are in a gray zone in which we are aware of what the client wants to do, aims to do, and therefore, of course, we should refrain, and we cannot avail ourselves of the benefit of the STR exemption. Now, in this context, the wording knowledge or purpose may be inferred from objective factual circumstances is something which we have thought for it to be introduced during the dialogue with the policymakers in the European Union, because we were afraid that the concept of knowledge could have been, let's say, interpreted in a lax way. We wanted to introduce a concept pursuant to which knowledge or purpose had to be and is going to be based and framed based on factual circumstances, meaning that, of course, it cannot be inferred per se. I think here, overall, we should be given the various proposals at the table then, and given, of course, the risk that the changes would have affected more strongly the perimeter of the exemption. I think we are to be, and we should be satisfied with what we have achieved in the dialogue with the institution. What we have not satisfied is the following point, which is, you see in the slide, is Article 2 on this second paragraph of Article 51. Constance, in her presentation, said that the EU was very happy to have the same rules for everybody. Of course, a regulation applies indistinctively in the context of the entire territory of the European Union. So no longer harmonization policies, no longer differences or nuances in different jurisdictions. Regulation, one for all. Is it true? Same rules? I'm not convinced at all, because there is this provision in the regulation, which has been, so I understand, wanted very much by the Council, which introduces something which I believe is might bring problems and poses itself to a strong critique by lawyers, should it happen. And this is, of course, a situation in which basically, you see, member state may decide that the exception does not apply for those type of transactions that present a higher risk of money laundering. So here we are that we could face a situation in which member states changes the rule differently from state to state. This side, the certain risks are higher than in Holland than in Italy, and basically creates a scenario of divergence within legislation. Why has this been introduced in the context of a regulation? Why has this been introduced in the context of such a delicate element, which is, of course, the mechanism and the perimeter of protection of legal privilege within the context of the legal profession? I don't know. I don't have the answer. I still need to point out, however, that it might be that we will not be governed by the same rules. So we will need to watch this point. We will need to be careful. We will need to, of course, be vigilant, because should this happen, we will need to oppose a situation in which something happening in Italy will be different from something happening in France or Germany when it comes to this specific provisions.
Now, Claudio, I'm going to interrupt you only because there are a lot of questions, very relevant questions, and relevant questions for you and some also for Constance. Do you want to, I mean, we have still about 10 minutes left. I leave it to you. Do you want to still speak for a few minutes, or should we go to the questions?
No, I think I will cover very briefly other 2 points I want to make.
Sure.
On the other pieces of legislation, and then leave it up to the questions if it's fine.
Right, because there are a lot of very good questions. Thank you.
Very good. I will go very quickly. So I'm happy there are many questions. It means that at least hopefully I have created a little bit of debate. Now, in terms of the next pieces of legislation, and I will go here really quickly. The indication that Constance made are indeed very correct when it comes to lawyers. I think we should be proud in the context of the directive of having indicated in the recital on Article 69, recital 69 of the directive, we have really fought strongly in requesting the insertions and the clarification that while the member state exercised the supervisions on bars, that the authority should not really handle or have a voice or have an effect on individual cases handled by the local bars. We were concerned during the dialogue that with the authorities, we were concerned that this provision might alter the independence of bars, might have an effect on independence of bars. And this recital 69, clarifies that this is not going to happen. On top of that, the clarification which you see in the last line of Article 69 protects the fundamental rights of bars, and in particular clarifies that the action of member states should not interfere with the exercise of the right of defense and confidentiality. I think that this wording is important. I think it's important that it's been included. And what we are talking here is, of course, Article 38, the power of oversighting self-regulatory bodies by member states. Very briefly, here again, the matter at stake was and is the independence of the bar. We were concerned in making the policymakers understanding the importance of the independence of the bar. I think we were able to do that to a very large extent, as I have expressed and outlined. The concern that I have, if you want, is Article 3B of this provision, where the action of member states may amount to measures and sanctions for failures of independent bars to comply. So what are these measures? What measure would be carried out? Will they be really effective? Jonathan, I see you appearing.
Yes, yes. We have we have 5 minutes left, so we should really move to the questions. Sorry, Claudio. Just to say, because we're having questions about that, the slides will be put up on the European Lawyers Foundation website under webinars. So you look for the tab on webinars, and you will find the slides there as soon as we can put them up afterwards. And you can also
let me just finish.
I would really like to go to the questions, actually, Claudia, because we'll never get it. Just to say one other announcement is that, because some people have not been able to get into the webinar, the recording will be put up as well as soon as possible. Please tell your colleagues who couldn't join, because we've had so many people, that they can watch the webinar. If you don't mind, Claudia, if we could go to the questions.
Maybe I can intervene if possible just before the question.
Sure.
Okay, what I want to say firstly on the exception of the exemption. Firstly, it's not a novelty. It was previously in recital, I think, 8 of IMLD 4. We just have co-legislator have decided to make it clearly in the text. That's the first thing. On the exemption of Article 51(2), as regard STRs and this mechanism, it's the wish of the co-legislator. It was not in the Commission proposal, but I just like to, because we managed to do that, you should have a look of recital 81 of the IML regulation will say that this power to identify higher risk situation should be based on an assessment of fundamental rights. And so we have tried to have safeguard here as well. And it's a wish from the co-legislator. I know this is a novelty, but just to say that we have tried to frame this power, which for us as well is a bit not what we have wanted at the beginning, but we try to frame it in recital 81. That was just what I wanted to add.
Okay, thank you. There was a question both about the independence of the bars, which you were concentrating on, Claudio, about whether the public oversight of self-regulatory bodies affects the independence of the bars. And your view on that would be?
Of course it does. Of course it does. It is indeed, however, a matter of how it does effects. To what extent it does. Can it be managed and suffered by, in this context? I mean, let's be frank here. The policymakers have subject every subject entity, every SBR to supervision. So we, of course, try to make them understand that we were different, but they hear from every subject entity that they're different. So they're not willing to hear us, even though if we make them understand that we exercise fundamental rights for the clients and for the system. So that battle there is lost. So okay. What here, however, I think that what we have introduced in the system is safeguard, which protects our independence, as Constance correctly says. However, what I disagree with Ms. Desaunette is when she says, no replacement for SPRs, just checks. Well, here, warning, let me just make here very, very, very quickly. Yes, you're checking. Of course, you're reserving your rights substantive. You're reserving yourself substantive powers when an SRB is not behaving correctly, probably rightly so. But then warning, when you say warning is not binding, I have some doubts when it comes to the wording of the provision if we really can say that it's not binding. But
okay. We'll try and get another question in quickly, which is that we had a question about the various cases from Pantelis Christofides, whether the Commission has taken account of, for instance, the Belgian case brought by the Order van Vlaams Sabalies and Belgian Association of Tax Lawyers regarding the new AML package. And also, he then asked later about whether it does take into consideration the European European Court of Human Rights cases, which I'm sure both of our speakers are familiar with, like
yes.
Michaud against France.
Yeah, you're okay. But
go on,
yes,
Constance, you want to speak?
but
Go on, please.
I perfectly know these two cases, one of 2007 in front of the CGE, European Court of Justice, and the other of the European Court of Human Rights in Michaud contre France, if I'm not wrong. And okay, what I have to say, of course, we have taken into account those cases, and those two cases are about two things. They validated the perimeter of the lawyers as obliged entity with the carve out when they are activity as regards defense of the client, and the possibility for lawyer to exchange information and transmit information as regards money laundering to competent authorities. So of course we have those cases in mind, and we do not have chain one comma as regard the perimeter of the lawyer, and the exception that Claudio mentioned previously, it just in line with this as well. So of course we have those two cases in mind. We are the European Commission, we try to follow the law.
Understood. Claudio, very briefly, because we should move on, we're on time. Any comment on the case law and the new AML package?
No, I think that, of course, we will speak about it on the legal privilege session. The sentences and the judgments of the European Court have been taken into account, are being taken into account, are important, do not change for us a lot, except that, but we will cover that in the legal privilege portion. So I think that...
okay.
Maybe can I just add something?
Yes,
on the
please,
public oversight body? That just to say, firstly, it's an obligation from the FATF. So first things, we have to follow FATF recommendation, and is in it. The other thing, and I have to again to stress that this public oversight body will just check over the SRB, will not replace, this authority cannot take a decision over an obliged entity. It's not possible. And you have this in the recital 69. And I wanted to say another operational reason, because I don't know from where the lawyer is coming from in this seminar, but when we have to draft this package, there is a FATF obligation first, but 1/3 of the Bar Association, in their opinion, do not do inspection. And a lot of those, when they did inspection, do not do follow-up measures. So what we wanted to ensure with this provision is just to be sure that and you keep this right to this specific supervision, and you are not the only one. Just the legal profession have the possibility to have SRBs. We have removed the real estate sector. You are the only one. And we want to keep this, and it's legally, we want to have it, but we just want to make sure that the supervisory task of the Bar Association is just realized, just carry it out.
Thank you. We really must move on. Claudio, you're coming back, so you have another bite of the cherry. Constance, thank you so much for your excellent presentation and answering the questions. I'm sorry to those people. We have some wonderful questions, and we will try to get them at the end. We may or we may not. We must move on to our next session, and this one is called Complying with AML Obligations, Practical Advice for Law Firms and Sole Practitioners. And our speaker is Emma Jane Williams, who's Policy Manager for Money Laundering, Anti-Money Laundering at the Law Society of Ireland, which is the regulatory, educational and representative body for solicitors in Ireland. And she has specialized in AML and lawyers for many years now, and represents the Law Society in various national AML bodies, and is a member of the CCBE's AML committee. Emma Jane, your slides are up there. That's great. Over to you. Thank you.
Great. Thank you very much, Jonathan. It really is an honor to be invited to speak today. It's a fabulous conference theme, and already I've learned so much about the AML package from the two speakers already. I'm going to, though, take a step away from the new package and provide some more, hopefully, practical advice for lawyers navigating lawyer AML as it currently stands. As we know, the package will not make any substantive changes to AML duties for lawyers. The duties will instead be embedded, elevated in a sense, from a directive to a regulation, but they aren't changing, bar the concern that Claudio has highlighted around suspicious transaction reports. The big changes are really there in terms of supervision at national and supranational level for the first time ever, and that will have an impact across smaller operations over time. I'm going to talk about duties which apply to lawyers now in a practical sense, And I'm talking about the fourth directive on money laundering essentially here and the changes it introduced a long time ago. The tick the box approach to AML compliance is gone. All those types of features were removed, moving all obliged entities instead to the risk-based approach, which will be in the new regulation as well. When I hear the question sometimes, what do I need for a specific type of client or a specific type of legal service? What do I need in terms of AML due diligence? I worry that the new, well, old at this stage, risk-based approach is perhaps not fully understood because the CDD, the customer client due diligence, has to be risk appropriate and not formulaic or tick the box. There is never a one-size-fits-all approach to AML compliance. Risk assessments are embedded, not only in the business risk assessment, that firm-wide risk assessment, but on a customer and matter level, the instructions that a client gives. CDD itself is linked to risk, so your customer risk assessment must be used to determine what CDD is to be applied. And it's not just due diligence on individual clients or customers. Policies, controls, and procedures are linked to risk as well. For lawyers, these requirements are not something that are coming down the track. They are very well established across the EU, and legal sector regulators, bar associations, and the Law Society in Ireland are supervising and enforcing compliance with these duties as we speak. These will, in the future, be in the new regulation, the rule book. So with all that in mind, here are some questions which I hope will help get you AML ready now, especially if you are a small firm or a sole practitioner, a form of 10-point checklist to ensure you are AML compliant. And I'm just, oh, there we go, next slide. So, do you know what is at stake? This is a really good question to ask yourself. And I think it's because there is no harm in emphasizing that there is much more than AML compliance failure at stake. AML, by its nature, is there to prevent money laundering. If you get it wrong, the repercussions extend beyond AML compliance failure, beyond a supervisor checking your AML compliance, because there is the risk of the offence of money laundering. There is a harmonised definition of money laundering across the EU. It's been a potential in Ireland for some time, and we have a very broad definition of the offence of money laundering in Ireland. The knowledge thresholds are very low, and the offence encompasses the proceeds of all crime. The offence can attract in Ireland a sentence of up to 14 years imprisonment, and it's harmonised at 4 years across the EU. If something does go wrong on the compliance or money laundering risk front, there is the risk to reputation and livelihood down the road also. And I think this underscores the importance of using AML to prevent more than just AML compliance failure. And it brings us back to the importance of looking at your AML strategically and in a risk-based way. There is a huge benefit in setting aside that narrative. We can often hear that AML is overburdensome. If it helps small sectors and small firms to remove or reduce the risk of unwittingly being used to launder money, AML instead can be perceived as an opportunity when so much is really at stake. There are wonderful AML resources available to you, which are tailored to lawyer AML, and these are available to every lawyer across the EU. While so much can be learned from resources for other sectors, I really do believe that the greatest impact in terms of AML compliance effectiveness can be achieved by referring to practical sectoral guidance. So I'd encourage you to visit www.aml4lawyers.eu. These resources have been hugely successful with overwhelmingly positive feedback. This project was awarded by DG Justice to a consortium composed of the two organisations of lawyers working at EU level, namely the European Lawyers Foundation and the CCBE, the organisers of today's conference. The user manual, I think in particular, contains everything you need to know about AML as it affects the legal profession, and it's available in many different languages. 3 videos are also available, each of approximately 3 hours in French and English, and they are from AML for Lawyer webinars, which took place in 2021. But the content is relevant today and will remain relevant under the new regulation. And I'd also recommend that you look at national guidance relevant to your sector to ensure you are complying with your supervisor's guidance and practical know-how relevant to your country. And certainly important, at least for the time being, while the rulebook and any possible future AML direction or guidance evolves. Next, I want to step away from the AML for just a moment. Please, when thinking about AML and looking at these resources, do not forget about sanctions. It is a criminal offence to fail to comply with sanctions. And I've linked to, in the slide here, to 3 resources: the European Commission's dedicated sanctions webpage. The European Council's infographic is really excellent in terms of giving you an overview of sanctions and how they apply. And rapidly responding to the introduction of sanctions on Russia over Ukraine, the Law Society introduced a sanctions resource hub. It's accessible by visiting www.lawsociety.ie/sanctions, and the link is there on the slide. And it contains information and resources to assist lawyers ensure compliance with sanctions. We have on that 3 steps designed to very much with sole practitioners and small medium firms in mind. No AML compliance program or strategy would be complete at this stage without detailed sanctions, assessment and policies. And I think the legal profession need to be alert due to the risk that countries and people subject to sanctions may start looking for ways to move assets to avoid sanctions. And solicitors really and lawyers should really make compliance with these sanctions a top priority. Sanctions evasion typologies is a good segue, I think, back to money laundering risks. And I think this is possibly, one of the important items to cross off your list. I always place, do you understand how professional money launderers might target you? I always place an emphasis on the importance of expanding your knowledge of legal sector risk. And this is because developing a good understanding of legal sector money laundering risk is vital to adopting that risk-based approach to preventing money laundering and also ensuring effective AML compliance. It's so very important to understand how lawyers can be used to launder money. You can't do AML. You can't be AML compliant if you don't know how the services you provide might be vulnerable, or if you don't know how the red flags to be on the lookout for are. As a starting place, I think it's helpful to know how law firms can be attractive to professional money launderers. It's interesting to look at how lawyers are vulnerable during all of the 3 individual stages in that 3-step process description of what money laundering is. Placement, for example. Well, that can happen if a client arrives at a lawyer's office with cash to purchase property for themselves, or possibly someone else helping a client with a significant property purchase trying to place cash into the legal sector via lawyers. Layering. Well, client instructs a lawyer in a fraudulent debt collection or a sham litigation is the risk here. And integration can happen when selling or transferring property, for example, a company business purchasing property for an individual. No amount of identity verification or customer due diligence will help when there are these types of money laundering methodologies or schemes in play. And the 2013 Financial Action Task Force report on vulnerabilities in the legal profession looked at the different types of lawyer knowledge around money laundering risk and the actual level of involvement in money laundering. And this graphic taken from the report explains the different types of lawyer knowledge that can exist. And research found that lawyer knowledge existed between 2 possibilities, neither complicit, neither unwitting. And that's the bit I think to be really mindful of. Somewhere in between is where lawyers can get caught. And I want to highlight how innocent involvement is where there are no red flag indicators apparent, moving to unwitting, where red flags are missed or the significance is not perhaps understood. This is not a good place to be, and it is better to spot red flags before agreeing to provide a legal service if it is high risk and there's red flags. It splits off then into deciding to provide a more high-risk legal service and making reports. Obviously, the most alarming aspect is the willful blindness, corruption and complicity where there are red flags present. My colleague will shortly provide an excellent presentation on specific red flags relevant to the legal sector. These are central to effective AML. You can't do AML compliance if you don't know what these red flags are. So I will be very short on the red flags themselves. I just want to flag that if there is one place to go to expand your knowledge of legal sector risk, it is that 2013 report by the Financial Action Task Force. And this slide is really just a takeaway, which summarises those, but there is more information coming up. I think knowledge of these red flags will reduce the vulnerability of firms to being used to launder money. I can't emphasise enough the value in everyone who has a client-facing role in your firm, knowing the red flags so that if they come across them, you then have the opportunity to assess before proceeding. There's a real opportunity to prevent your firm from being targeted and also save headaches down the road if you might have preferred to have disengaged had you been alerted to event earlier. Next, consider, have you evaluated your firm's vulnerability to being used to launder money? Once you understand how lawyers can be used to launder money, the next step is to evaluate the current threat to your firm. Known as the business risk assessment, this requires firms to take a bird's eye view of risk exposure. It's a concept that has been there for many years now, and it's linked into firm policies around AML. This is so important. It's a statutory duty which you need to fulfill, but it is a strategic step also because it is something which can help you see where risks you might want to strategically avoid might be. It is an approach which ultimately will help reduce a firm's exposure to being targeted by money launderers. It's an opportunity to pick and choose more high-risk services, perhaps online, non-face-to-face, and decide at business model level. These may be too high risk or too complex and costly from an AML compliance perspective. This is really helpful to smaller enterprises. Different ways to go about. Start with a bank actually complying with your duty to complete a business risk assessment. You can start with a blank page. All of the different risk factors you need to consider are set out on this slide. Or adapt the sample adaptable business risk assessment developed by the Law Society. It guides you through the issues you need to consider. No two business risk assessments will ever be the same. Every practice has different clients, provides different legal services, and in different ways. Ultimately, you need to have well-developed understanding of legal sector risk and types of legal services you are open for business for. Moving on, have you put risk-appropriate AML compliance policies, controls, and procedures into place? Once you've completed your business risk assessment, you can then move on to developing your policies, controls, and procedures, which are risk-appropriate and relevant to your firm. This will help reduce your firm's exposure to money launderers and help you demonstrate compliance with the statutory duty to develop policies, controls, and procedures. It's important to be aware that there are some very specific duties around what policies, controls, and procedures need to address. For example, senior management approval or buy-in and keeping under review are at the core of this. These policies are vital in firms because they help determine at that strategic level how AML-regulated legal services are provided. They present a really beneficial opportunity to take the decisions about whether to provide certain legal services at all in your policies, controls, and procedures before you might even be targeted by a professional money launderer. Your PCPs need to outline controls, policies, and how risk is mitigated. For example, many firms refuse to accept cash, and others have very strict controls over the provision of account details for transactions to ensure they are happy with regard to funds before the money is ever transferred. They also present an opportunity in terms of their policies, controls, and procedures to outline and define staff responsibilities around AML and communicate to staff that they must be followed. PCPs need to be at the heart of every firm's AML framework, connected into your business risk assessment and helping determine processes for customer risk assessment and risk-appropriate CDD. They help move away from ad hoc CDD and really can prevent a crisis in your firm. Next, do you risk assess for money laundering before agreeing to act and gathering customer due diligence? Now, moving away from that firm-wide AML duties to AML on individual clients and matters where timing really is key. The purpose of CDD, customer due diligence, is to get you to ask questions to get to know your client. But you won't know what questions to ask until you risk assess, until you start to look under the bonnet. Before taking a case on, proceeding in a case, you need to think about whether there will ever be a combination of documents which will remove the personal risk of committing the substantive offence of money laundering. Sometimes it's not necessarily that you're suspicious, but the level of AML compliance might be too complex or outside of your expertise, particularly for smaller firms. Risk assess as early as possible and throughout as needed to ensure compliance with client and matter risk assessment duties. Protect yourself and your firm first and the compliance and CDD aspects will look after themselves. Because once you risk assess, you'll be able to decide what CDD you need to verify your client's story. It's so much more than gathering identity documents. This item is on the checklist to make sure you empower yourself to be able to spot when somebody might be trying to use you to launder money at the best time for you. Do not jump to collating identity documents or bank statements, especially where potential risk exists. Don't make the mistake of seeing AML as a way to stay safe. Remember, there is more to this than keeping your file in order. AML, by its nature, may be anathema every other aspect of your training and role as a lawyer. It goes against your core duty to clients and reorientates it on a statutory basis in specific circumstances to the member state, changing lawyers into a form of gatekeeper. But that duty to client has always had to be balanced. It has never been about blind loyalty to clients. It is a fact that the legal profession across the world is consistently being targeted by money launderers. And if it is the case that a client could use you to launder money, anti-money laundering may in fact help you. And in particular, those client and matter risk assessments, deploy them before engaging or agreeing to act. Don't put the cart before the horse. Risk assess before you agree. And what do you do then when you spot a red flag or multiple red flags? First, focus on deciding whether or not you will provide the legal service and what information you will need to help with this if it might be possible. For example, when risk assessing, it can be helpful to bear in mind a general rule of thumb from that Financial Action Task Force 2013 report, and that is, if there are a number of red flags, it's more likely a lawyer should be suspicious. I think this emphasises the need also to consider red flags in context. In practice, document your thought process around this, record it, and this will help you then to be able to demonstrate your compliance to your regulators. Bear that Financial Action Task Force rule of thumb in mind. The mere presence of a red flag versus a number leading to suspicion. Think about whether there is a legitimate explanation for one potential red flag, and think very carefully before you continue if there isn't. Next, on your compliance checklist, ask yourself, have you adopted the traffic lighting red flags approach? You might find it helpful to start following this approach when you are actually risk assessing red flags. I designed it to help contextualize and rate red flags when they arise. It's here just to mention it as a very practical way to approach your AML, and especially when trying to interpret or risk rate red flags. My colleague very shortly will look at red flags in detail, but once you've expanded your knowledge of legal sector risk, please do come back to the traffic lighting approach. It's a color-coded traffic light system around the scenarios and case studies, suggesting what might be very high risk in red, medium in orange, but with good CDD may move to more standard risk and standard risk in green. You really need to be careful if you are being asked to provide a legal service in circumstances similar to the red-coded scenarios here. If you're interested in adopting this approach and learning more about it, please go to the last half hour of the training in English on the www.amlforlawyers.eu training that was back in 2021. Next, ask yourself, are you documenting your customer matter risk assessments? This checklist is here to communicate the importance of making sure you are this checklist item is here to communicate the importance of making sure you are documenting your compliance with statutory duty to risk assess customers and matters or individual instructions. It is so vital to capture your compliance with this duty. And it's vital that you document your customer risk assessments to be able to demonstrate in the future to your regulator your compliance with the duty to risk assess clients, and also to demonstrate that the CDD, the customer client due diligence you completed was risk appropriate. In Ireland, we have published a sample form to help solicitors document their compliance with this duty alongside a risk factor questionnaire. Over the years, these have become a key resource to help solicitors in Ireland demonstrate compliance with customer risk assessment during inspections carried out by the Law Society. And documenting risk assessment, capturing it for regulators and supervisors and bar associations, it's essential to be able to demonstrate compliance. Don't do all that good work of risk assessing and applying risk appropriate CDD and not then have it ready to show your regulator. And finally, do you engage with the due diligence as it comes in? Another key item to ensure your AML compliance is fit for purpose. Make sure that you are engaging with the due diligence as it comes in. And it's really vital to do this. After you have agreed to take on a legal service, even if traffic lights are green and it's standard risk, it's important to ensure that a red flag doesn't arise as you progress and to engage with it if it does. For example, if funding all of a sudden comes from somewhere unexpected, look at the due diligence that follows initial risk assessment. Look out for last-minute changes or substitutions, checking back to see if there are any red flags, and documenting your thought process around this. You're not expected to be Sherlock Holmes here, but you do need to interrogate the due diligence. There's more at play than putting copies of documents on file. Are you happy that things are happening in the way you were originally instructed? Does the due diligence dispel concerns or provide legitimate explanations around a potential one red flag? Remember, sometimes money launderers will know what to say to get past your firm's onboarding systems, to get you to provide a legal service. And then it is up to you whether or not you are engaging with the due diligence as it comes in. Very much there is a potential that people will test the AML controls you turn up in place. So by working through these 10 questions, we've
Emma Jane, we should stop because of questions.
No worries.
Okay, and I'm not sure whether the questions are for you or for Claudio. Claudio, are you there? Are you ready to come live? Because they may be for you. So 2 people have asked the same question, and I'm happy that either of you answer it, which is to do with if in a real estate you are acting for one party, say the seller, do you have any obligations in terms of due diligence or anything else in relation to the other party, the buyer? What are your obligations if you're acting for one party in relation to the other party?
Yeah, so I suppose that you know, in the spirit of how I've approached AML today, it's that kind of bird's eye view and not getting into the specifics. I would say, as a general rule of thumb, park the AML CDD piece and thinking, do you have due diligence on non-clients? The question is there, if there is a risk and you're seeing a red flag, don't ignore it. So put your, if you approach it with the mindset of you want to use your AML to make sure that you don't expose yourself to money laundering risk and you don't participate in any money laundering unwittingly, if you're always on the lookout for money laundering red flags, irrespective of whether it's your client or the other client, the other person in the transaction, or beneficial owners even, and I think that's the best way to approach it.
Okay, and Claudia nodding, that's great. We have another question from Anastasia Mostrovaki, which is on the same kind of issue. If it's not your, if a lawyer is informed about money laundering, but not while representing a client in front of judicial proceedings and has nothing to do with the defense of this client, does the obligation of reporting apply?
I'm thinking of that one, and I'm thinking I'm going to ask Claudio.
Claudia, do you have any views on that question?
I've not understood in a situation in which the attorney is not representing, has no relation.
So, in other words, what happens if you're a lawyer, but you're not acting for a client, and you hear about money laundering? You have any obligation to report?
But of course, the obligation to report are related to the professional engagement. Now, when it comes, however, to a situation in which it's described, the one you described, it is for us citizens to see what we need to do. I mean, are you saying the crime being committed on the street? You call the police. So is the situation? If there is analogy there, of course there is. I think there is. So when it comes to us being citizen, if we feel that it's important that we do make a report, we do it, but we are not obliged to that. I don't know if you agree, Emma, but
I do. I would just add to that, though, that it's important to think about whether there might be duties to report beyond AML in individual member states. So you'd need to check that on a national level, and also on an EU level in terms of sanctions. Again, think about AML and sanctions together. There are reporting duties directly effective if you suspect that there is sanctions breaches or evasion taking place, and there's information on the EU websites and also whistleblower tool as well.
And there's, again, another question which has been asked twice, so it's worth quickly asking before we move to the next session, which is, somebody says, I'm going to put them together, is there an accepted method to identify a client in long-distance advice, i.e. where you don't meet the client in person at the outset of a mandate? But there was also a question about that the current draft from Cornelius Hiller, the current draft agreement limits identification measures, on-site inspection and EIDAS signatures. Is this the end to video identification in general? So those two questions are linked. Do either of you want to quickly answer it before we move on?
Yeah, I'm happy to take that. I will certainly be looking at that. That's just been pointed out by the question. But as we stand at the moment, this is something that we had to develop guidance on in Ireland around the time of the coronavirus, where people could not meet their clients face to face, and business had to keep going. We looked at what was the position in different countries. There was really good guidance available in Canada at the time, which we embedded into guidance in Ireland. There can be limitations depending on different countries, and I believe there was one in the UK at the time. But generally speaking, there shouldn't be a bar on providing an AML regulated legal service if you don't meet your client in person on the basis that is risk appropriate. There is nothing there to alarm you that there would be higher risk for money laundering, and there are various tools and packages that you can sign up for, which look at biometric identification. But in response to the coronavirus crisis, we developed something very, very quick, which was that you do video call, you get the client to hold up their passport, and you also have then your copy of that sent to you. But again, it has to be risk appropriate that you actually want to move into that space.
And Claudia is nodding. Claudia, we will move into your session. Somebody has just commented on one of the answers, and Claudia, I'm going to leave this with you because the person has said, so people who seek legal advice on money laundering will always need to be reported, even though we're not assisting them. How will they ever be able to get a lawyer? That's a rhetorical question. You can deal with that in your presentation. Claudia, we come to you again. Thank you so much, Emma Jane. Sorry, we had to, and we've had a comment in here saying, great presentation, Emma. So there you go. So thank you very much indeed. Claudia, we come on to you now. You've been introduced, and this is the application of legal professional privilege in the context of AML obligations. Over to you.
Thank you, Jonathan. You can hear me and you can see the slides, right?
Absolutely, yes.
Yeah, well, the purpose of this, if you want, pit stop with legal privilege is because is not by chance. Legal privilege is indeed very significant element in the context of our profession. It is something we need to understand and learn about and being aware of in the context and in the delicate balance between rights and their enforcements and in between the attempt and the purpose of states and entities to pursue legitimate objectives of protection against important crimes such as money laundering. So the purpose of this, chat with you here today is really to go back to basics, explain a bit about what it is that we're talking about when we talk about legal privilege, and explain the developments up to here, and maybe make some interrogate ourselves on what could change in the future when it comes to legal privilege. Of course, we all know the provisions scattered in important pieces of legislation regarding legal privilege. We start with the Charter of Fundamental Rights, Article 7, respect for private life, Article 8, protection of private data, Article 41, right to good administration, covering expressly confidentiality and professional and business secrecy. We go, of course, and move on the Convention on Human Rights. And again here, Article 7 and Article 8, right to a fair trial through legal assistance. Article 8, respect for private and family life. But then, of course, we have a directive, the one that you see cited on the slide, which, again, provides for the identification and need to respect by member states of the confidentiality of communications. Articles 2, 3 of the Code of Conduct of European Lawyers covers confidentiality, the essence of a lawyer's function, and a primary and fundamental right and a duty of a lawyer. Not enough, we also have international instruments like the United Nations Basic Principles on the Role of Lawyer of 1990, covering, of course, the need for governments to respect and recognize all communications and consultation between lawyers and their clients. Then, of course, we cannot forget that each national legal system in the EU provides for specific rules. One source I can cite, I'd like to cite very briefly, is the Edward report. And I cite it with pleasure because Judge Edward has been not only an important judge at the European Court of Justice, a Scottish judge, indeed, but also a former chair of the CCBE. And in 1976, he provided for a paper covering at that time in the members of the CCBE at that time, and that paper has been expanded and now it really is a very important source covering national legislation when it comes to professional secrecy. The European Court of Justice came across a legal privilege before 2007 in two important cases. Let me just cite them here, because here the cases were about the interaction between legal privilege and antitrust. These were investigations of the European Commission, and basically the bulk of the question was: is this quality of being lawyers a restriction, and which could entail a restriction relevant, or can be wiped out by antitrust legislation? Basically, I'm oversimplifying, but in that context, the European legislators said, no, we need to respect legal privilege, and we need to clarify what it is. The purpose of it is a public interest. It has a constitutional dimension. We need to, of course, allow it to remain untouched, if you want. Everything changed, as we all know, in 2007 with the case of the European Court covering the delicate balance between new European AML legislation covering lawyers and legal privilege. We have just seen this morning the provision of the new regulation, which remained, as we said, the same, and which provides for the exemption on the legal privilege and an exception to the exemption. That exemption, i.e., an exemption which covers, of course, the possibility, the right for lawyers not to make STRs, suspicious transaction reports, when it comes to litigation and the acknowledgement of the legal position of the client. In these two contexts, in these two situations, we are allowed not to make a report. Why? Because of legal privilege, of course. Now, however, in different scenarios, so in situation which cannot be taken within this exemption, lawyers need to make a report. So in 2007, the court, we appealed, of course, that system. We attacked the provision. CCBE intervened as amicus curiae in court, and we tried to convince the judge that it was very important, the court at that time, that was extremely important to maintain the system as it was, without exceptions, without lawyers to be called to make an STR. And the court said no. The court said the system as it was laid down was sufficiently balanced and took into consideration the position and the role of lawyers and the importance of legal privilege, because the obligation of information and the making of the STR does not infringe, you see it in the slide, the right to a fair trial, as guaranteed by Article 6 of the Convention, which I just cited before. So 2007, we have pleaded. We went to court. We have lost. Almost 20 years have passed. Have we come to terms with this? Have we tried to change and obtain from European and national legislators a change in this position? Yes, we have. We have tried. But we have mostly, for national legislation, lost. So all throughout Europe, there's been also national cases. I won't cite them here, but the principle that you see there in the slide, when it comes to the fact that, yes, we understand that legal privilege is important, but however, in this context, in context of the fight against money laundering, and given the fact that the legal privilege is respected and protected when it comes to fair trial, this position at national level hasn't changed within the European Union. Let me now cover two new cases I'd like to bring you and comment very briefly about. And these two cases are recent, are cases of 2022, both, and are cases of the European Court. Why do we cite them? Why do I want to talk to them about? Because I think to a certain extent, they provide materials and food for thought in a context in which one might say that the wind of protecting legal privilege and understanding and respecting legal privilege to a certain extent is changing. Is changing in the eyes of the court. Is this a radical change? Maybe not. However, there is a change. So we need to identify that and comment briefly these two cases to understand what change this is. Now, the December 8th, 2022 case is interesting, and it pertained to the DAX 6 tax legislation. I'm not a tax lawyer, but just to briefly give you the background, within DAX 6, within the DAX 6 system, basically tax professionals and lawyers are called upon, blow the whistle and report to the authorities when they see that clients are seeking aggressive tax schemes. So here, once again, the legislator comes to us and says, tell us if something is happening which I believe is wrong, aggressive tax schemes, when it comes to me being informed. The tax system, which provides for this rule, included also lawyers in the rule. And the exemption of lawyers in the context of that rule were exactly the same that is now in force within the AML system. However, and on top of that, the provision put an obligation on lawyers to report to the other members of the advisory scheme, to the client. And therefore, there is a provision on top of that containing the obligation for lawyers to report and inform the other professionals of the client. Is this correct? Is this possible? Is this right? Is this in line with European law and in line with the value and the strength and the force of a legal privilege? The court said no. And for the first time, issue a judgment which basically said that lawyers cannot and would not be able, you see that in the slide, to carry out satisfactorily their task of advising, defending, and representing if they were obliged to cooperate with the authorities by passing them information in the course of the related legal consultations. And here again, we are in a context of tax advice given to clients when it comes to aggressive tax schemes. I think this wording is important because, yes, it comes in a situation and it covers an area which is very similar to the one which we've been seeing before in the context of the 2007 judgment. And it's also important to see in writing and in the judgment the attention and the understanding of the court when it comes to what we work, what we do, and the relevance and the relevance of the legal privilege in the context of defending European rights and citizens' rights. Because, and I open a bracket, legal privilege is not a tool for us to manage as a little club of happy professionals, but it's a right of a client. It serves the purpose for the client to be protected. It serves the purpose of the system to function. And I close the bracket. So I think this is an important judgment. I think is relevant. When it comes to now asking ourselves, will it be this judgment a change? Is it bringing a radical change? My answer is no, however, because the court basically assessed that lawyers should not make the report in the context of these tax schemes, but because there were many other professionals who were there doing it. And so in the context of balancing the situation, they said, we believe that in this specific context, lawyers can be exempted to report. Should we bring again the case before the court in trying to change the 2007 case? I do not believe that this would be sufficient déroulement, sufficient change, a radical change. However, it's there and it's important, and maybe I'm wrong. So I wanted to point this out for you. Jonathan, how many
wonderful.
minutes do I have?
Well, if you're going to answer any questions, we have 6 minutes left of your session, and really there are a lot of questions. So I would like to ask some questions now, but if you want to finish what you're saying for a minute, you can do that. But there are very good questions.
One minute, just to tell you that on top of this case, there is another one in 2022 on beneficial ownership register, a Luxembourg case, very interesting, because it covered the interaction, has been cited before, between Article 7 of the Charter of Fundamental Rights and the accessibility of the register itself. It blocked this, it nullified the provisions of total access, and it also gives an indication that the new wind is blowing, a wind that protects and has a new eyes vis-a-vis the necessity to protect privacy and certain delicate, important information. So please, Jonathan.
Wonderful, thank you. And Emma Jane, you can I'll be on standby in case these are also for you. Martin Polimanov has said, should a lawyer establish whether the company manager is a PEP, a politically exposed person, or does this only concern the beneficial owners of the company?
No, the PEP, the situation of a PEP, the profilation and identification of a PEP pertains to the client. So the client, and if the manager is the legal entity, of course, the client, therefore representing the client, we need to identify, to verify whether he's a PEPs or not. So it pertains to the client. If the client, i.e. the legal entity that we represent, is represented by a PEP, we need to, of course, increase the level of attention and increase the due diligence.
Right, thank you. Franz Doppelhofer has said, once the money laundering is completed and a client seeks legal advice, I assume he means after that, should there be no obligation to disclose any information? Am I right?
Well, if there is a criminal case at stake, if there is the protection or a defense of the client when it comes to an indication of him or her having committed potentially a crime, of course, there is a shield, a total shield. We are advising the client in the context of the protection of an investigation, for example, that is taken against him or her. So, of course, in that context, when it comes to litigation or facts prior to a possible litigation, we are protected.
There is a question here. It was actually the view of the Commission, but I'm interested to know what your view is about what will happen in the event that the FATF recommendations conflict with the Court of Justice and European Court of Human Rights case law.
Well, this is a very interesting question, Jonathan. Very complex. FATF is soft law, not public international law. So I believe it's relevant. It has a relevance. Member states adhere to FATF recommendations, as we all know, but it's soft law. So courts, in my opinion, again, courts would probably give a priority with other stronger public international law instruments, and the convention that I have just cited and the regulations, which are the interna corporis of any legal system.
This may be a question for Emma Jane. She hasn't come on, which says that CRA sample document, is it possible to use this in non-EU countries?
Yes, I don't see why not. You know, it's designed very much. I think we were inspired by a document that the Law Society of Scotland had developed. So it originated there. We developed it then to make sure it was in compliance with national legislation in Ireland. It's in compliance with the spirit of where AML due diligence is. for lawyers at an EU level. And again, that reflects what's mandated by the Financial Action Task Force globally. So yeah, I think definitely relevant beyond the EU.
Thank you. One last question for you, Claudia, from Miomir Joksimovic. What measures can the AMLA bring against the bar if there's non-compliance?
This is a good question. There is a certain degree of disagreement between myself and probably Constance on this. I'm sorry that she's had to leave for our engagement. But to make the long story short, there are sets of legislation in the package. It's clear that when it comes to actions of the AMLA, they need to be respectful of secrecy, secret information, private information. They need to not infringe privilege and do not and cannot affect single specific cases. So this is clear. This is written. This is one, if you want, in the context of the dialogue, because in other pieces of the proposal, this was clear that they could really come into and come into the decision-making process of the bars. Now, when it comes to, there is another set, however, of provisions that basically say, and that both AMLA can take appropriate measures and issue warnings and issue actions and carry out acts that with the purpose of making sure that certain behavior of the SRBs are corrected. So this is a dialogue that we have been, we will need to engage further. For example, when Constance said that lawyers do not have in place sufficient investigative powers or sufficient actions vis-a-vis the members of the bars. We are just as CCB preparing a report on this, and I can assure you that this is something which is totally wrong. We do a lot. Most of the state have important safeguards and carry out a lot of activities when it comes to investigating and making sure that lawyers adopt proper behavior when it comes to AML.
Perfect. Thank you. Only because we're so short of time. Thank you very much indeed, Claudia. Indeed, for your excellent presentation. Emma Jane, thank you for your support. We come now to our final speaker, and I'm very pleased to be able to introduce the session on what to watch out for money laundering red flags. Our speaker is Arne Engels, who is a member of the CCBE's Anti-Money Laundering Committee, and he's a German lawyer who's a specialist in banking and capital markets law. So Arne, over to you, please.
Jonathan, thanks a lot. Very happy to join this meeting, and I'm very thankful for all the insight I've already received. I'm very thankful also to Emma Jane, who already started a little bit my topic as well, so we can skip a few things, and given the time being, we start with the ideas. So if everything works.
Yes, it does. It does.
So that's a little bit about me. You can find this later on. And as I already mentioned, we have heard lots of topics already, and most of you are sitting in front of this screen a little bit like this, I think. So lots of new things, lots of ideas. But as usual, the best is still to come. We are talking about yellow and red flags. We are doing more about red flags today. We need to be aware of that red flags are mentioned mostly as main points. But I want to make you aware of a few things, because the money laundering prevention, everything that's happening today, everything we have to do, is nothing without the people. You can do checklists, whatever you want. There is nothing there's no checklist that will ever be a 100%. There will be money laundering things which you are not able to understand. But if you have a guts feeling, that's the main important thing. So the main important factor is sitting in front of everyone's computer now. That's you. Be aware of this, because that's the main thing. If you have a bad feeling, if you have a bad understanding of the case, if you have the understanding that something is too good to be true, then mostly it is. So be aware of this. And having said that, let's start with the types of services. We have lots of services that are related to AML issues that we need to be aware of. Purchase of real estate, of course, is mentioned everywhere, especially in Germany. It's one of the biggest topics. I'm quite sure the money laundering through real estate is a little bit less than it was 4 or 5 years ago, but it's still existing. And we are facing lots of issues on red flags. So we had the discussion last weeks with one of our supervising authorities that one of the lawyers should be aware of that the price of one piece of real estate was getting much more higher than it should have been. There was a developing ongoing on the stage, and someone wanted to buy it for real good money. So is it money laundering or not? We don't know. In our case, from our opinion, it was still obvious that's part of the business deal. From the other side, supervising authority said, that could have been different. Creation of trusts, companies, and charities, as well as the management of them, we all know, be aware of it. If you don't understand why they are doing it, what they want to do, that's one of the biggest issues. Charities, we all know, are used not only for good things, but also used for financing terrorism. That's one of the biggest issues we had last October, November, starting again, when money was tried to be put on the actual conflicts. Terrorism financing is also something we need to be very aware of. We also, Emma Jane already mentioned that Russia and Belarus have been mentioned in these circumstances as well. So be aware of everything that's happening with us. Use of clients' accounts. If you get clients' money, you should better know why. We come to this later on. And if they want you to send it back to a third-party account, then it's definitely, in nearly 100%, it's a money laundering issue. Sham litigation, that's just an ordinary thing. We all have heard about the laundering machines in Moldova and Malta that have been acting a few years ago. If a case is too easy, be aware there could be something inside. That's everything, that's about God's feeling. We have official risks that are mentioned everywhere in all the papers and all the documentations we have. We have geographic risks, first of all. Countries subject to sanctions. We all know sanctions issues have become very much more important within the last 2 years. Be aware of people can be on this list, although you haven't seen them. Be also aware that there is a big world running around sanctions these days. So companies that have changed, especially ownership in February, March 22, there might be something involved in sanctions. Services risks. I don't read this slide, so you can do it by yourself, but be aware there are lots of services where can be used for doing these things. I've already mentioned the payments. Consideration is inadequate or excessive. So if someone is very keen in what you are doing and why you are doing it and how you are doing it, and that's somehow not the normal case. Usually clients are very happy if you provide some services, but if they got too close, you always have already a feeling about them. And maybe this feeling might be also connected to money laundering, especially if they are willing to pay extraordinary fees. So be aware of, we all know money laundering. They know that they are losing money somewhere on the way to get it clean, but extraordinary fees is one of them. We already talked about, or we have already spoken, there was a question about PEPs entities. Be aware that's every time it's a big issue where you see people coming from the databases. Look into the databases. They are as a little bit already public available, not for every country. And please, we can also advise doing checks with ICIJ databases. They're also providing very good red flags to special persons or companies or names that have been shifted from Panama to other countries, for example, Dubai, in the last years. So there are lots of issues where you're facing red flags, where you can see red flags, and every time you have this feeling that something not working out directly, be aware of it. Cash-intensive businesses, we all know about this. That money is put away, and you pay via casinos also your losses sometimes. So be aware of this, but there's always lots of reasons. Red flags, clients' behavior or identity, I've already mentioned it, why it is doing the transactions the way it is. Be aware of that. You need to know who is behind everything, who is the ultimate beneficial owner. Be aware of the source of funds. If the client is somehow evaluated a little bit more high risky, you should do very proper assessment about these issues as well. There are some other red flags inside use of intermediaries without good reasons. We all know if the structure is too complex for the case, that's one of the issues. We know that there are lots of European structures, especially for avoiding bankruptcies or securing financing. We have lots of Luxembourg structures these days in bigger companies because they have a very good law for securities, which is causing lots of questions by smaller banks because they don't understand why this is to be done. Falsified, counterfeit documentation. Please be aware of it. It can always happen. So please be aware of looking inside the originals. As we have already mentioned earlier these days, video identification is one of the issues. The German authorities have mentioned that we are going towards the video identification like the banks. So this is one of the issues. If you don't find your client on the internet, that's already a good thing. I've seen you, Jonas, but I'm still taking 2 minutes. I'm needing another minute. And be aware of relationships. So you can, it's everything. If you make, oh no, that's not happening, you're on the more or less safe side. But if there's something you don't really know, you understand there might be issues, be aware of it. There is usually something. There's a reason, and if you don't understand the reason, be aware of it, that you might be in a very high risk area also for yourself. Funds, we have already mentioned it, be aware of where is this coming from, especially if they are not used in traditional money ways via the IBAN system or usually a SWIFT banking system. There is one of the issues. And we all know that has been a very much, so sorry for making your head even more bright looking like this one, and I'm very short on time. And if you have other questions, feel free to contact me at any time, and thanks for your attention.
Thank you so much, Arne. I'm sorry you had a shorter session than the others, and thank you very much for doing that. We are 2 minutes from the end. I do propose to ask one question, and anybody can answer it. Arne, you have the first go if you want, which is a question, if I've understood the question correctly, it's where lawyers are offering a registered office and a registered secretary for a company, or maybe only a registered office. What are the obligations in relation to customer due diligence? I don't know whether anybody wants to comment on that.
In Germany, it would be full scale. So it's high risk approach. You need to do everything, and you have to be very be looking also inside the businesses they are doing. So that's quite something more than they want you to know. So because it's not only renting the office and giving away your address, it's also reputational risk, and you have to look inside everything. You have to look inside all the transactions they are doing, and I'm quite sure no one wants us being a lawyer.
Wonderful. Thank you so much, Arne. I'm sorry we could neither have more time nor more questions. Thank you very much to the participants for asking very interesting questions, not all of which we could answer. We've come to the end of the time. I just want to make two announcements. Repeated questions have come in about the availability of the slides. I told you at the outset that the slides had amazingly useful information on them, all of them. And so they will be available on the Foundation's website where you can get it. There will also be the recording available. We had today, as you will doubtless have seen yourself, 1,000 participants, a lot of participants. If you missed something, if your colleagues want to look at this webinar, the recording will also be available on our website or on our YouTube channel. We've exactly reached the time. I like to finish on time. I would, on behalf of all the participants, like to give applause for our very excellent speakers and also for their very excellent slides, which are a real treasure house of information. Thank you very much. And I'd like to thank also our participants for their wonderful questions. Thank you very much, everybody. This is the end of the webinar. Thank you all for your participation, and we hope to see you at another of our webinars soon. Bye-bye.